The broadcast is now starting. All attendees are in listen-only mode.
Well, good afternoon, everybody. My name is Matt Godson. I'm co-CEO with Momentum Events, and it's my pleasure to welcome you here this afternoon to today's webinar. Before I go ahead and introduce the webinar and our panelists, a little bit of housekeeping. Firstly, the panelists have generously agreed to make the slides for today's presentation available after the event. I will be sending automatically everybody on this call a link tomorrow to both the slides as well as a recording of the presentation. So you will receive that automatically. You don't need to request those individually. The panelists will also be taking Q&A at the conclusion of the formal part presentation. You can either use the question box, which will be as part of your GoToWebinar panel on the right-hand side of your screen, or use the chat box as well. And I'll be sending you a couple of little messages there just to kind of highlight those during the course of the presentation. With that said, it's my pleasure to turn over to our two presenters today, Sanya Sukhdwang and Anthony Tridico, both of Finnegan, for today's presentation entitled Global Litigation and Patent Office Strategies for Biologics and Biosimilars in the Post-AIA World. Sanya, Anthony, welcome.
Thank you, Matt. Good morning, good afternoon, or good evening, everyone, depending on where you are in the world. I'm Sanya Sukhdwang. I'm a partner in the biopharmaceutical group in our Washington, D.C. office, and I'm joined by my partner, Anthony Tridico, who is our managing partner in our London office that was opened up recently. We believe we've got a great webinar for you today to discuss the interactions between the AIA, in particular IPRs, and also European oppositions as it pertains to biologics and biosimilars in the U.S. and throughout the world. And as Matt mentioned, we will be accepting Q&A towards the end of the session. We'll be reserving a significant amount or sufficient amount of time to take your questions and hopefully provide you sufficient answers. So as we go along, please feel free to send those questions concurrently, and that way you don't have to remember them at the end of the session. So I'd like to start out and give everyone just a little bit of background about the BPCIA, or the Biologics Price and Competition Act in the U.S. Prior to March of 2010, there was no automatic exclusivity for biologics in the U.S. And it really wasn't needed because there was no process to present a biosimilar or a follow-on biologic in the U.S. Unlike Hatch-Waxman and small molecule, where that's been around since at least 1984, a similar procedure wasn't in place, and thus the reference product sponsors, or the companies that own the BLAs and presented these products to the market, really didn't face quote-unquote generic competition. But with enactment of the BPCIA, there is a period of exclusivity. It's 12 years, plus you get some additional exclusivity, such as pediatric exclusivity tacked on to that. But the BPCIA also provided some benefits for potential biosimilars applicants.
You can still have, for example, an extended group, but as the sponsor or the mentor, or I'm trying to think of another
Excuse me, I'm hearing someone microphone in the background. Thank you. But the BPCIA also provides additional benefits for biosimilar applicants, in that the biosimilar applicant can get approval of their product immediately after expiration of the 12-year period of exclusivity. So again, unlike Hatch-Waxman, where you have to go through a 30-month stay of regulatory approval, no such stay applies for biosimilars. One downside or complicating factor in the BPCIA for both the reference product sponsor and the biosimilar applicant is that there's a very complex pre-suit patent exchange procedure. And as you can see here, when a biosimilar applicant files its application at the FDA, and I've been calling these abbreviated BLAs or ABLAs, they have to provide their application to the reference product sponsor. And once that happens, a patent exchange process begins. And that process, when you look at the entire timeline, takes about 8 months to go through. And this happens before a complaint can even be filed at a district court. And the thought was that if the parties are required to go through this exchange beforehand, it should lead to a more orderly litigation, and both sides should come to an agreement as to what patents will actually be litigated. However, when you go through the process and you look at it in more detail, and when you consider the stakes that are involved with biosimilars, it's difficult to come to the realization that parties will ultimately agree on what patents should be part of an initial litigation. And thus, this entire 8-month period, people are trying to avoid. And we've seen that recently in cases filed by Sandoz and Celltrion. So in this instance, even though the BPCIA was enacted in 2010, the first time we really saw any action involving a biosimilar was this year. And more specifically, Sandoz announced that it was conducting clinical trials for a biosimilar covering Amgen's Enbrel product. And what Sandoz did was, rather than go through that complex patent exchange procedure, they filed declaratory judgment action in California against Amgen and challenged Amgen's patents covering Enbrel. Well, Amgen moved to dismiss Sandoz's declaratory judgment action, arguing a number of things. One, that the product was not final, and thus the issue of infringement was not solidified, warranting declaratory judgment jurisdiction. And the reason why they argued that the product wasn't final was because Sandoz had not yet completed its phase 3 clinical trials. Amgen had also argued that there was no immediate harm or injury because Sandoz had not filed its abbreviated BLA. And finally, although not a major part of their brief, Amgen did argue that the proper way to resolve these patent issues is to go through the BPCIA procedures and patent exchange process. Well, the district court agreed with Amgen and dismissed Sandoz's DJ suit against Amgen, and stated, as I have here, that they cannot contend and did not contend and cannot contend that it complied with the obligations under the Act, the BPCIA, because it had not to date filed an application with the FDA. Now, this case is up on appeal before the Federal Circuit, and oral argument was conducted in September. I attended that oral argument, and it's very interesting. Several of the judges asked Amgen some very pointed questions about what would be the real harm in allowing this DJ suit to go forward, because the thought was, according to at least to the judges, that when Sandoz files its ABLA, Amgen would then sue them. And Amgen's responses were good. First, they argued that until they file the ABLA, the infringement question is still up in the air because the product is not yet solidified in terms of what the final composition would be. They also argued that there's no immediacy here because the application wasn't filed. Under traditional declaratory judgment standards, if there's no immediacy, the DJ jurisdiction should not attach. And then finally, they did argue that the BPCIA was a proper means for resolving these disputes, and Congress enacted BPCIA in order to address these very situations. We're waiting for a decision on that appeal. Because it was argued in September, it hopefully comes down sometime, September, it will hopefully come down sometime in December or January. And that will be the first appellate decision interpreting the scope of the BPCIA. Now, like Sandoz, Celltrion similarly filed a DJ suit against Janssen involving patents covering Remicade. And this was in March of 2014. Like Amgen, Janssen filed the motion to dismiss, arguing no immediate injury in arguing that the BPCIA is the proper way to resolve this suit. But unlike the Sandoz case, Celltrion actually had filed their ABLA after they filed their DJ complaint. And on August 8th, they did make this announcement, claiming to be the first biosimilar for a monoclonal antibody filed in the U.S. Now, an interesting twist to this is just recently, as of last week, Celltrion actually dismissed its DJ action against Janssen. And the papers doing that dismissal are not clear, but one can speculate that because they actually filed their ABLA and have to go through that patent exchange process, and because a motion to dismiss was filed against them, that the DJ suit would not at this point move any faster than a suit brought through the BPCIA. But what does this teach us? Well, it teaches us that companies looking to bring biosimilars into the U.S. have a desire to resolve the patent issues well before entry onto the market, and even before, perhaps in some instances, filing their ABLA in an attempt to avoid going through that complex procedure. And it's not just companies filing biosimilars. I think companies that may be interested in filing biobetters also have an interest in trying to resolve any patent issues before they bring their products to market. Now, if the Federal Circuit affirms the district court decision in the Sandoz v. Amgen action and does not allow biosimilar applicants to file a DJ complaint before they file their ABLA, then it really limits the ability to challenge patents early. And that leads us to IPRs, because IPRs are a method that can be used to challenge patents that are not constrained by the BPCIA, and they've actually, as you'll see, have been used in cases involving biologics patents. Now, there are two types of post-grant trials that have been introduced via the AIA, inter-parties review and post-grant review. Because the patents we're dealing with really are much older, they don't necessarily qualify for post-grant review time frame. So our discussion is going to be focused in on IPRs, at least from the U.S. perspective. Now, here's a small chart comparing the difference between IPRs and post-grant reviews. IPRs are available after 9 months after the grant of the patent. Again, because most of the patents we're dealing with here are older, that 9-month time frame doesn't come into play that often. The threshold showing to get the IPR actually instituted is a reasonable likelihood of success. And that's an important standard to keep in mind because it's significantly less of a burden than the clear and convincing standard that one faces at a district court in order to invalidate a patent. There are some restrictions on what you can do in an IPR. They're limited to arguments under 102 or 103 involving patents and printed publications. You cannot bring a 112 argument. You cannot bring a 101 argument in an IPR. But why IPRs are actually attractive is because of the short time frame, 12 to 18 months. And one might ask, well, why didn't we see more of these challenges using inter-parties re-exam or ex-parte re-exam? It's really because those types of procedures took an extremely long time to get through the patent office and then ultimately up to appeal. Whereas here, within 18 months, you'll get a decision from the Patent Trial and Appeal Board, and then you can bring it up immediately to the Federal Circuit, getting that resolution in essentially a 2-year time frame. There are some additional limitations. There's an estoppel provision for the petitioner who brings the IPR. If you bring an IPR, you will be estopped from raising in the litigation issues that were actually raised in the IPR or that could have been raised in the IPR. This includes, for example, if you bring an argument under 103 in the IPR based on certain prior art references. In a district court litigation, you cannot argue that those references render obvious the claims, or, and it goes further than that, if you have new prior art references, you may well be stopped from raising obviousness based on those new prior art references in a district court, unless you can somehow establish that those references were not available to you during the IPR. Now, the scope of estoppel is still up for debate. A district court, at least based on our research, has not yet had to decide the issue and the scope of estoppel, but that is a factor that petitioners for IPR need to keep in mind. And then finally, the IPR is directly appealable to the Federal Circuit, again, shortening the time frame for resolution. Getting towards the time frame, again, the reason why these have been attractive to people challenging patents is because it's relatively short. Once you file a petition, the patent owner has the option of filing a preliminary response within 3 months. Once they file that preliminary response, the PTAB has 3 months to determine whether or not to institute the IPR. And if they decide to institute the IPR, that IPR needs to be concluded to a final written decision within 12 months. Now, if the PTAB declines to institute the IPR, the decision is not appealable to the Federal Circuit. So if there's a decision not to institute, that's final, non-appealable, and your only other recourse is to file another IPR, perhaps with different art, or then moving towards the district court. The IPR does allow for discovery. It is limited. It's primarily limited to declarations filed by experts and depositions of those experts and perhaps the inventors. But the PTAB, in their decisions, have been very reluctant to expand the scope of discovery for 2 reasons. One, it might inhibit them from completing the procedure within 12 months. And 2, they believe that one of their mandates is to make this process more streamlined and more cost-efficient than district court litigation. And if they were to grant more expansive discovery, they would not meet those 2 mandates. So why file an IPR? I've covered this a bit, but really the lower burden of proof is a major factor in deciding to file an IPR. Again, it's clear and convincing at the district court level, which is a very high burden of proof, whereas at the PTAB, it's a reasonable likelihood of success. Another major factor is that it is much less expensive to go the IPR route than a district court litigation. And finally, the very bottom, there's very limited ability for a patent owner to amend their claims in an IPR. Unlike re-exam, where amendments are allowed and usually granted and re-exam certificates come out because of amendments being made, the patent owner is pretty restricted and almost limited to the claims that they got issued. And if you are able to establish through prior art that those claims as issued are unpatentable, the patent owner has very little recourse to change those claims. This slide is recent as of October 16th. It just shows the number of IPRs, CBMs, and post-grant reviews being filed. As you can see, in October of this month, there's been about 60 IPRs filed, and that's about halfway through the month. We've seen that trend around 120 IPRs per month being filed, and until the Federal Circuit starts rendering decisions on appeal, we expect this trend to continue. With respect to bio and pharma type patents, about 5.7% of all IPRs being filed relate to this technology area. I think there are a number of reasons why it hasn't expanded. One is Hatch-Waxman. The paragraph 4 filers do need to have patents listed in the Orange Book in order to take advantage of their 180 days of exclusivity. If they challenge those patents in an IPR and get them invalidated, it removes their ability to get that exclusivity. So that's one factor as to why perhaps pharma patents haven't expanded in IPRs. Number two is that with respect to biologics, we're still very early in the game in terms of biosimilars. And I think companies are trying to feel their way around and see what courts are going to do. And the Sandoz decision will be very telling in this. If the Sandoz decision is reversed and companies are allowed to challenge patents before they file an ABLA, you might see that route taken as opposed to an IPR. However, if the Federal Circuit affirms the District Court's decision, then the only recourse biosimilar applicants have will be to go the IPR route. This slide just indicates that about 75% of all IPRs across all technologies are instituted. That's a very high number. Again, until the Federal Circuit starts issuing decisions on appeal, we expect that percentage to remain around 2/3 of IPRs filed actually instituted. This slide provides to you all of the final written decisions involving bio or pharma cases. And there, as of today, well, actually there's 14 now as of today. But as you can see, there aren't that many. We've provided the IPR numbers, and the PTAB actually have these final written decisions available to you. Statistics, patents have not fared very well in IPRs. Prior to earlier last week, no pharma patent has survived an IPR. All claims have been canceled. What's interesting, though, is last October 23rd, I think last Thursday, in the Ariosa v. Vernata IPR, the PTAB actually affirmed all 18 challenged claims. This was a diagnostic type patent, and the decision was primarily based on Ariosa's inability through their declarations to provide convincing evidence that the claims were obvious. If you read that decision, you'll come to realize that the criticality of presenting evidence through expert declarations that Anthony will cover in a moment. With respect to biologics, there have been IPRs filed against patents that cover biologic products. The first is Hospira filed an IPR covering Janssen's patents covering Eprex. In that instance, Janssen disclaimed all of the challenge claims, and because they disclaimed all of the challenge claims, the IPR was terminated. The next example, Biomarin actually challenged Genzyme's claims covering Myozyme and Lumazyme. Biomarin, if you go to their website, they are conducting clinical trials on a competing product. It's not clear if that's going to be a better or a biosimilar, but nonetheless, they filed an IPR in August of 2013. That IPR was instituted, and oral argument was heard earlier this month, and we expect a decision within 3 months on the outcome of that IPR involving Genzyme's product. Phygenex also filed an IPR involving Genentech's Herceptin product. Phygenex had a related lawsuit against Genentech in Georgia on a Kadcyla product. These IPRs have not yet been instituted, but we're expecting a decision on institution at the end of this month. And then finally, Laboratorius Solanés filed an IPR against BTG's patents covering Crofab, which is an anti-venom product. BTG announced earlier this month that they had settled this case against Laboratorius Solanés, but as of October 20th, the IPR had not yet been terminated. So what we see here is clearly a desire for companies seeking to bring biobetters or biosimilars onto the market, a means of obtaining freedom to operate before they are able to market. And the companies have taken two very distinct courses of action. They've taken the Sandoz action in trying to bring a declaratory judgment action prior to filing the ABLA, and so far that has not been successful. And other companies have taken the IPR route, trying to clear the path well before they file their ABLAs through this less expensive and faster route, and as of to date, actually quite harmful towards patent owners. So again, it'll be very interesting to see what the Federal Circuit does, both with the Sandoz case and what they do with respect to the PTAB's decisions on appeal. And until then, we expect the number of IPRs involving biologics only to increase. Now I'm going to pass it over to Anthony, who is going to discuss some strategies for petitioners and patent owners with respect to IPRs, and also cover to some extent what goes on in Europe and what companies can do to protect or challenge patents related to biologics in a unified patent court or in the EPO. So with that, I turn it over to Anthony.
Thank you, Sonia. Appreciate that. So let's jump right in and talk about some strategies. And let's start by talking about some strategies for the petitioner, so the person who wants to challenge the patent owned by the BLA holder. So first of all, I think you need a good story, a good theme when preparing your petition. You know, the board, I think, makes it very clear, the PTAB, that they want the information, you know, spoon-fed to them, that you have to provide your case up front in your initial petition. So you're going to lay out your arguments, your evidence, your expert declarations, everything to support your arguments in that first filing. And you want to surround that by a theme, a good story. You know, why are the issued claims, which the Patent Office has already looked at, why are they invalid? A couple of things that you need to keep in mind when preparing this petition. I said this is very different from those of us who are used to post-grant challenges, such as the challenges you have in Europe of European opposition, in that we are providing this entire case up front. You know, first and foremost, as the petitioner, you have to provide or propose a claim construction. Now, not every term, obviously, but any term that you think is important to the application of the prior art, we're talking about an IPR, or let's say we're talking about a PGR, so we're raising an issue of written description or enablement. And while there have been very few PGRs so far, most of that due to the fact that you can only file a PGR against an AIA patent, I think we will see more and more PGRs, obviously, as more patents become available. But I also think Sonia showed you that percentage of biotech and pharma being a very small percentage of the IPRs that have been filed so far, 5.7%. You'll never have as many PGRs as IPRs, I don't think, because obviously PGRs, the time window is narrow. But I think what you'll start to see is probably a higher percentage of the PGR filed being against bio and pharma patents because of the importance of issues like 101 patentable subject matter, enablement, written descriptions, those arguments being very important in those technologies, and those arguments being, I would say, arguments that you often want to make in front of the Patent Office, the PTAB, who understands those arguments, who deals with those arguments on a regular basis. It may make, for many, the forum at the Patent Office much more attractive when you're considering one of these 112 or 101 type arguments. So going back, we're presenting our whole case. Looking at the claim construction, you'll want to propose a construction for terms that will be important to a written description or enablement argument, for example. It should be interpreted very broadly so that you can make an argument with regard to the written description or enablement of that term. So as the petitioner, this is your opportunity to influence the claim construction, because when the board, when the PTAB makes its decision on institution, there is going to be a claim construction provided by the board, and they will construe claims, and this is your chance to influence that. So highly recommended, petitioners, you propose the construction of important claims. You provide expert declarations, extremely important. I don't think I would file a post-grant challenge without an expert declaration, and it should include the person of ordinary skill in the arts analysis of the prior art. Obviously, if we're talking about a novelty position, then having a claim chart, for example, that walks through the art and compares it to each claim element is going to be key. But as soon as we start getting into the world of obviousness inventive steps, we're going to want to have an expert declaration supporting an analysis of the prior art you're providing, and also providing a clear explanation to the board, supported by cites to references and cites to the prior art of what the motivation is, what the expectation of success is, providing where that comes from. A real factual basis to support this argument for non-obvious or for non-obviousness or obviousness, excuse me. When you have seen, I think, petitions fail to be instituted, it's because they haven't really provided that factual basis to the board for something like an obviousness or obviousness challenge to the claim. So very important, providing that how, why argument, articulated reasoning by an expert that's really going to support your arguments, and you provided that all up front to the board in that initial filing. If you could change the slide, Sonia, please. As I mentioned, that declaration, extremely important. It has no page limits. We have page limits of 60 pages and 65 pages from a PGR IPR. We have no page limits with regard to the declaration. It really is our opportunity to lay out an analysis of the references and our underpinning and factual information that we can then just cite from our petition. You cannot include attorney argument. If attorney argument is included in the declaration, your petition could be bounced by the PTAB. Also, it could be counted against your page limits as part of the attorney argument. So you don't want to include attorney arguments, but you have to support everything by data or citation to the prior art or references. Make sure you comply with all the technical requirements and the procedural requirements laid out by the board. And very important, the client can't be a patent law expert. What the board is looking for is a technical expert who's really going to dive into the information and really is going to provide that underpinning of your motivation to combine or your unexpected results, and that can be supported by data or citations to the art. As I said, I think the declaration is very important, and I wouldn't really want to go forward with an IPR or PGR without having that expert support. And since this person is someone who's going to be cross-examined probably in the proceeding, you also want to make sure that whoever is providing this expert evidence is going to be a good witness, that they're going to do well in the cross-examination and stand up to scrutiny when they're questioned. Sonia, will you change the slide, please? Now, as the patent owner, what are some of the things that you want to consider as counterattacks? I think it all starts with prosecution. Of course, we want to obtain strong patents. We want to make the job as difficult as possible for the person challenging our patent. So that would include having claims of varying scope, clear fallback positions in your patents, not just dependent claims that add an element, but the dependent claims that add elements that add to the patentability of the claim. It's very difficult to amend your claims during an IPR or PGR proceeding. So far, there has been one motion to amend that has amended the claims that has been granted by the board. So having these fallback positions in our cases when they issue is going to make it more difficult. We're providing those fallback positions and so that we can argue their patentability and not rely on having to amend the claims during the proceeding. It also is going to increase costs for the petitioner, more claims to challenge. They may have to resort to multiple petitions in order to be able to put forth the arguments for these number of claims. It also, and of course, is going to increase the likelihood that one or more claims will survive. You may want to consider multiple patents. Again, making their job more difficult. If it's an important product, multiple patents. I would even consider, if you have narrow claims to your product, have them alone in a standalone patent, the narrow claims, and go for the genus later. Have that clean case that covers your product specifically. If your broader claim that's going to provide more protection, pursue that maybe in a later continuation application. Trying to maintain continual applications if you expect your patents to be challenged, because again, very difficult to amend during one of these proceedings. Having a continuation pending, you can do the amendments in front of the patent office once you see how potentially an IPR or PGR plays out. Along that same vein, I would recommend considering filing a reissue if you're hit with one of these attacks. The reissue application will probably be stayed by the patent office while the IPR or PGR moves forward, but it will give you an opportunity, if the claims are lost in the IPR or PGR, to have something pending, that reissue application pending, where then you can maybe salvage something from your case that you wouldn't have been able to do through an amendment because of the difficulty of amendments. Just like I mentioned for the petitioner, you want to have a good story built into the specification, but also part of your papers to the board. What's your theme for patentability? What story are you trying to tell? And for important products, before this ever happens, long before you expect to see a challenge, looking over your portfolio. Are there any corrective actions we want to take? Do we want to file a reissue long before we see a challenge, where we narrow the claims, or where we file a reissue application excuse me, to put in fallback positions or file a continuation from the reissue application in order to build other layers of protection for our product? We can always do that if we're narrowing the scope of our claim. That's a basis for reissue that we can do anytime during the life of the patent. So something we want to consider very early before we see an attack, so that we've done our best to make sure our position is in best shape for a later challenge. Sonia, you can continue. Also want to consider what declarations have been filed during prosecution. Why? Well, the procedure is set up such that once the petitioner has filed their petition to challenge your patent, as the patent owner, you can file an optional patent owner response. I think there's two important strategic considerations with regard to that patent owner response. The first is, it's your opportunity as the patent owner to influence the initial claim construction of the board. So for that reason alone, you have to strongly consider whether or not you want to put forth that patent owner response so that you get an opportunity to argue what the claim construction should be. It's also an opportunity to provide legal arguments with regard to the institution of the PGR or IPR. But you're not allowed to provide data, however, or evidence. However, if there is declarations, evidence that are part of the public record already, you can rely on those as part of your argument. The whole goal as the patent owner is to do everything you can to avoid institution of the IPR or PGR, because the statistics show once instituted, you're on the defensive. The board has determined more likely than not that that claim is invalid. So we want to avoid that situation by trying to argue in that patent owner response why it shouldn't be instituted. So if there is data or declarations already public record you can rely on, you'll want to do it. Arguing against the claim construction, challenging the date of a reference, whatever it is, that's allowed in that first filing by the patent owner. That's our goal, is to try and avoid institution. The next slide. Never too early to prepare. Doing your diligence much earlier time frame than in the past. As Sonia mentioned, you can avoid, and people can avoid and are avoiding, the timing of waiting until they can file, their biosimilar application to challenge by using these procedures. So they're going to potentially be challenging you earlier. You want to be looking at your portfolio very early to prepare for these challenges. That means conducting your own prior art search so you understand what could be raised. That may lead you to then take some corrective action with regard to your patent through reissue, etc. Start collecting and establishing secondary considerations, whether it's testing, commercial success, praise of others in the field, anything that you're going to use maybe during those proceedings to establish the patentability of your claim. Have that collected. Once these get going, they move quickly, and a lot's going to be going on. So very early on, I want to have my experts lined up. Even before this happens, who are my experts going to be? Are they in line with our arguments? And what information are we going to use to support our arguments? Again, never too early to prepare, because once these get going, because of the one-year timeline that they have to be complete after institution, they move very quickly. So as a patent holder for an important product, I want to have considered this beforehand and make sure that I have my strategy ready to go when I first see that challenge. Okay, Sonia, next slide. Yeah, that includes keeping an eye as the patent owner on oppositions of your European-related patents, or as a challenger, the European opposition is a great forum to test some of your arguments, to test how the patent owner may respond to some of your arguments. With regard to oppositions, and let's take a look at how we can use those in conjunction for more of a global strategy with PGRs and IPRs in the U.S. Oppositions, we usually view them with a 1/3 rule. A third of the claims that are opposed are rejected, a third are revoked, and a third are maintained in amended form. So basically a third survive without any amendment. So about 70% of patents are wounded somehow during an opposition. And those statistics are pretty consistent over the years. So it does provide us with an effective ground to maybe test some of our arguments. Can you go to the next slide, please? You know, if we compare some of the available challenges, EPO opposition is very similar to a PGR or CBM. We can raise any issue of patentability. The only issue not available that's available in the U.S. is clarity. So we can raise any issue of patentability in the European opposition, novelty, inventive step, insufficiency, added matter. Unlike a PGR or IPR, you don't have to put all that evidence up front. You have to raise the ground, but you can provide evidence, et cetera, more arguments later in the proceeding, so you're not required to have that case prepared quickly. An opposition has to be filed within the first 9 months of issue, so it does, again, provide you maybe a testing ground for some of these arguments. Also, since it's a lower cost proceeding than a PGR or IPR, there's no discovery to speak of that takes place. It can be a great option to gather intelligence or to maybe force some information from the patent holder that you could maybe later use in a PGR and vice versa. So what do I mean by that? If you can go to the next slide, Sonia. If we look at the timeline between European opposition and PGR or IPR, they're rather similar. The time of an opposition, the European Patent Office has been moving much more quickly over the last few years. So you are, in most cases, seeing a hearing in front of the opposition division within 15 to 24 months, and you're given a decision on that same day. So you find out when you walk out the door what the decision is. You can then use the submission to try and get information from the other side, and try to parse out strategy from the other side, knowing what the timeline is and when filings and different information are due. So you go to the next slide, please. For example, what can I use from an IPR or PGR in opposition? Well, if the IPR or PGR is taken first, there's discovery. So patentee's own data, if it shows inconsistent results, sworn statements by the patentee, anything I've gotten in cross, arguments, prior art, all that information I can use in an opposition. And since there is some discovery and cross in a PGR or IPR, it gives me more of an opportunity to gather information I could turn around potentially and use in the opposition. From the opposition standpoint, if that's what's been filed first, well, any of the submissions, arguments, as I said, testing ground for some of your positions. Also, it gives you a good idea of how the patent owner may respond to some of your arguments. You'll see how they are going to amend their claims, for example. What's important to them? How are they going to view this art, and how are they going to respond with amended claims? Maybe their amended claims aren't as important to you, or the patent isn't as important to you once the claims are amended. So again, a good testing ground to try and parse out some of the strategy that you may be faced with. You know, any statements made by the patentee on claim interpretation, things of that nature, those could all be then turned around and used in the IPR or PGR on both sides when you're establishing claim construction or arguments that you're going to use in your petitions or response. Sonia, next slide, please. Shifting gears a little bit, the options in Europe are going to change substantially in the coming years. As the unitary patent, and this is now a question of when, not if, comes online, we're talking about a number of different options for challenging, but also as a patent holder, a lot of decisions and strategy with regard to how we're going to protect our product. So when we look at this, basically what we're talking about is a system where instead of having a bundle of patents that have been, excuse me, that have been ratified in individual countries that we then have to go enforce in individual countries, by choosing the unitary patent, we will be able to have one enforcement option that will be good through all the countries that are part of the system. And that's one of the big questions, is how many countries, when will be part, and when will they be part of the system? So Sonia, if you could go to the next slide. Just quickly, a summary. Like I said, it creates, in essence, a European patent that will have unitary effect in 25 of the 28 European Union states, it appears, once everyone has ratified. That excludes Italy, Croatia, and Spain, who for the moment have not agreed to be part of the system. The argument made by the European Commission, as I said, Brussels, has always been that there's a cost savings. That remains to be seen. I would question that conclusion, and we really won't know about cost savings, at least from a patent, in obtaining a patent standpoint, until we have some indication of what the costs are going to be from the European Patent Office. But it does create a simplified translation agreement, an arrangement for the unitary patent, no longer having to have a patent translated and even the claims into a number of different countries. There'll be no validations, and you'll pay a central annuity. That's why there's an argument for less cost. Again, we'll get to that in a moment. There's a question as to whether or not that's the way it plays out. The most important aspect is this creation of the Unified Patent Court, I think. It'll provide decisions that are effective throughout how many countries sign on. I say 13 to 28. You have to have 13 countries ratify, including France, Germany, and the UK, in order for the procedure to go into force. Right now, France is the only big three that has. The UK is currently debating it. Germany is expected to ratify in the near future. I think you've had 6 or 7 other countries that have ratified to date. So it's still in a process of ratification. Once ratified, the decisions will be effective in those countries that have ratified. They will have exclusive jurisdiction to hear all infringement and revocation actions for EP and unitary patents. Now, during the first 7 years, and this is important and goes into the strategy of considering whether or not you're going to choose a unitary patent, is during the first 7 years, you can choose to opt out and potentially opt back in. What do I mean by that? Well, by opting out, you could choose to just go the route of we use today. So not choose the unitary patent, choose to go the traditional route of ratification in all the different EU countries, then enforce in each of the individual countries. Even with your current patents, once this goes into effect, you can choose to opt out a current issued patent, so it's not part of the system, and you can use the national courts. One of the questions that is yet to be answered is, will there be a fee for opting out? There seems to be some agreement among users that there's going to be some fee for opting out. They want people to use the system, so having some opt-out fee seems to make sense. How much that's going to be and whether or not it's going to lead to more people choosing a unitary patent than would otherwise is something that we need to keep an eye on. Now, in addition to having an ability to enforce your patent, the other advantage or disadvantage, depending on who you are, that comes from this system is a central revocation proceeding. Oppositions were originally designed because you would get a patent at the European Patent Office. The idea behind an opposition was you could have one challenge to challenge the patent before it was ratified in each individual country, and you had to go challenge the validity in each individual country. It gave you a central proceeding. A unitary patent will have a central revocation proceeding for the life of the patent. So think of it like a lifelong PGR for the patent. You'll be able to challenge the patent through the unitary court system for any issue of patentability anytime during the life of the patent. For patent holders, that's a scary proposition. No longer will you know after the 9 months that the window has closed for challenging a patent, and it can happen anytime during the life of the patent. It'll probably be a more expensive proceeding than at the European Patent Office. But again, one action being able to kill your patent prior to when you may have enforced that patent. So, as we were talking about with IPRs and PGRs, someone who's considering filing a biosimilar application, they can strike early in Europe by using a central revocation proceeding and wiping out the patent before they are committed to going in a direction. Now, that could be one benefit is why you may want to opt out when it's available to you during that first 7 years. If you've opted out, then it's not available for a central revocation. It follows the old proceeding, and you have fewer, the chance of someone then challenging your patent, they have to go to all the national systems like they would today. Anya, can you? So the way this will work is upon notice of allowance at the EPO, you will have the option of choosing unitary effect. So you would have unitary patents that the EPO would issue. There would also be national validations for countries that are not part of the unitary patent system. Spain, Italy, for example, also Switzerland and Norway, which are not part of the EU. The other option would be to go the national validation route as you do today. That will be your choice during the first 7 years. Once the transition period is over, then you'll have to go the unitary effect route. Next slide, please. This leads to a lot of different considerations and a lot of options, especially over the next 7 years. Now, for example, we will have the opportunity to file a unitary patent, to use the traditional method, or national filings. National filings will never go away. Still filing, for example, at the UK Patent Office and having a UK patent through the UK Patent Office. Those will remain. So for the next 7 years, we have 3 choices. After the 7-year transition period, we'll still have the option of national filing if we want to avoid the chance of a central revocation, or we want to not take advantage of the central court. So a lot of different factors that I've listed here on this slide can go into whether or not you choose and which of these you choose. You know, talking to a lot of users of the system here in Europe, I think a lot of people are considering that they will use some mix moving forward. They'll still keep some patents in the traditional EPO route. They will definitely choose the unitary patent for some of their portfolio so that the option is available to them to enforce throughout Europe with one patent, but not all of their patents could be knocked out in a central revocation. And some are even considering a little heavier filing in the national patent offices to always preserve the ability to use the national courts as opposed to having to use the European court once it comes online. Next slide. It'll be the good aspect, the positive, is that you'll have a standard procedure for all the courts. You won't have what we have now, which is different procedures, different courts, different ways of looking at patents in the different jurisdictions. Discovery, for example, in the UK, no discovery, basically a written procedure in Germany. A bifurcated proceeding between infringement and validity in Germany, where everything's handled by one court in the UK. It'll all be standard procedure at all the courts. It's really an emphasis on written submissions with a one-day hearing. What I think you'll see when you look at the procedure, when you look at the timeline, it looks very similar to the way a PGR and IPR has been set up in the U.S. The timeline and the procedures are strikingly similar, except they'll be handling both validity and infringement in that time frame and in those procedures. So a very quick proceeding, a very efficient proceeding. You'll see it'll definitely lead to forum shopping based on the different courts, where they're located, the language, the judges, who the judges are. Very similar to in the U.S. when we're choosing what jurisdiction that we're going to file it. You know, there has been a lot of compromises. You have so many different traditions in so many different countries with different language. Of course, there's a number of compromises. Tanya, next slide. At the moment, there are a number of local divisions. You can either have a local or regional division. Think of both of them as like a district court in the U.S. So country can have a local division where you'd be able to file an infringement action. If the country is a smaller country like Sweden, Finland, Estonia, Latvia, and Lithuania, they've decided to have a regional division. So if you're bringing an infringement suit on a unitary patent, you would bring it in that regional division for infringement in any of those countries. The central division will handle the central revocation. So if you're challenging a patent, you would file that at one of the central divisions. The regional divisions can also always defer a court to a central division. There will also be an appeals court, similar to like we have the Federal Circuit. There will be an appeals court whose seat's in Luxembourg. You can go to the next slide. The central divisions where you would file the revocation to challenge a patent will be located in London, Munich, and Paris, with the Pharmaceutical, Chemical, and Medical Device Court located here in London. So as a challenger, someone who's challenging validity, that would be filed here in the London court against the unitary patent. And again, and the scary part of that as a patent holder is that is any time during the life of the patent. Next slide. As I mentioned, there will clearly be forum shopping. There's different rules for where you can bring the infringement proceeding, where you would bring a revocation or declaration of non-infringement. You're going to look at the language of the divisions. You're going to look at the judges. There'll be a lot of opportunity to potentially forum shop, as there is today in terms of determining what country you want to bring to. Next slide. As I mentioned, the timeline that has been put forth in the rules is very similar to what we see with PGRs and IPRs, except you're looking at very much a written procedure that's done in a 12-month period, handling both validity and infringement. Next slide. The last thing I wanted to cover is just quickly, what do you do? What's your strategy moving forward? Do you elect the unitary patent or not? Once this goes online, which is probably sometime next year, I think there's a lot of considerations. And as I said, I think people are looking at some kind of a mix moving forward over the next 7 years. There's clear advantages to opting out, depending on the cost, because you avoid the central revocation. There's clear advantages to opting in because you get the one enforcement throughout Europe. You can also choose to opt in later. If you choose to opt out initially, again, that'll determine, a lot of that will be determined by the fees. You also have to look now at where you validate your patents. If you validate only in Germany, France, the UK, Spain, and Italy, like 88% of the users do, then there really is no cost savings to a unitary patent. In fact, it's probably going to cost more. Again, all things that you're going to need to consider as we make this decision over the next year in terms of what our strategy is going to be and how to best protect our portfolio. With that, and I know we don't have much time left, I will open it up to questions. Thank you.
Thank you very much. Anthony, Sonia, thank you so much for a fantastic presentation. We are very close to time, so we will, depending on the length of your responses, we will probably have time for one or perhaps two questions. So the first question was for Sonia. Other than challenging the basis of the petition in a preliminary response, are there other arguments a patent owner could present?
Yes. As you know, the patent owner, after an IPR petition has been filed, has an option of filing a preliminary response to try to convince the PTAB not to institute the IPR. One mechanism or one argument that we've been contemplating, really formulated out of Hatch-Waxman, but it goes to the idea that Congress has established a very specific procedure for dealing with challenging patents that cover biologics, and that's through the BPCIA. And one argument that we've thought of making, and we haven't seen it made yet, is to argue in a preliminary response not the substance of the challenge, but really the ability or desire for the PTAB to actually handle an IPR or PGR involving a patent covering a biologic. The argument could be made that Congress has determined the process through the BPCIA. The IPR, PGR is in contradiction of that process, and because they're in contradiction, the PTAB has the discretion to not institute it. Again, the thing to remember is IPRs are not automatic. The PTAB has its discretion to institute or not institute, and the argument would be they should exercise their discretion, not take IPR challenges against patents covering biologics, because the proper mechanism to handle those challenges, as already determined by Congress, is through the district courts and the BPCIA. So that's one other option that patent owners might consider.
Okay, and our last question is for Anthony. How does the company coordinate U.S. and European challenges and defenses against challenges?
I think the key is communication. It's important that they are coordinated. As I mentioned, information can be used from one and the other. You have to make sure your arguments are consistent, or you'll get called on it in front of the PTAB or in front of the opposition division. So again, it's all about communication. It's making sure that your counsel is integrated, working closely together, working closely with in-house counsel, so that you are making consistent arguments, that you are presenting the same story, and that you're using the procedural benefits of each to help you in the other proceeding. So I think number one is communication, and making sure that your counsel is working closely across the jurisdiction.
Well, that's wonderful. Thanks so much. Well, I really appreciate the time that you've both taken to prepare today's presentation, as well as answering the questions. Just as a reminder, the recording of this session and the slides will be made available to everybody. So watch out for an email from us in the next day or so. I will also mention, it's a slightly shameless plug, that Momentum is planning the second IP Council Exchange on Post-Grant Patent Challenges at the PTAB, which will be taking place at the end of March next year in California, and I'll make sure that a link to that is included in the message also. With that, that's all from me. So Anthony and Sonia, if you'd like to say your goodbyes.
Thank you, everyone. We appreciate the time you've taken to join us this afternoon.
Yes, thank you very much. And of course, if you have any questions, always feel free to reach out to either one of us.
That's wonderful. Well, that concludes today's webinar. Thank you so much to everybody for joining and for your attention today, and thank you again to our presenters. Enjoy the rest of your day. Thanks and goodbye.
Bye-bye.